1. Contract law defined. Contract law in today's market. The term contract means a legally enforceable promise made by one person to another. In real estate, there are many different types of contracts, including contracts for sale, options, mortgages, leases, contracts for deed, escrow agreements, and loan commitments. Each of these contracts should meet the requirements described in this section. Contracts are comprised of considerations, duties and obligations, for both a buyer and a seller that, when met, help ensure the fulfillment of successful property transactions. Contracts contain a number of promises or terms to be performed or not performed by the selling party and the buying party. The person who contracts any promise is known as the promiser, and the person who is owed the promise is called the promisee. In most contracts, both parties become promisers and promisees. Note: a law that is known as the Statute of Frauds requires that some contracts be written and signed by all parties to be valid. Contracts involving the sale of real estate are generally included in the Statute of Frauds. Origin of contract law. The origins of contract law are found in the early common law of the Middle Ages. With population increases and interest in owning land, the need for organized and systematic methods of land ownership and development was needed. Early forms of contract law help provide for the protection of land acquisition. The distinction that the law drew, in terms of identifying the enforceability of rights, was between formal agreements and informal ones. A formal agreement was one made in writing, and was authenticated by the practice of sealing. In the history of law, a wax seal affixed to a contract had special legal significance. A sealed contract was said to be under seal or sealed. In the courts of common law, a sealed contract was treated differently from an unsealed contract. Seals are still sometimes used on contracts. However, they no longer take the form of wax, but instead consist of impressions made on paper, and they serve mostly symbolic purposes, except in the case of the notary. 5 characteristics of enforceable contracts. Because a fair and effective property transaction depends on the fulfillment of contracts, it's important to understand the characteristics of a legally enforceable contract. In general, in order to be defensible, contracts must include the following 5 characteristics. 1. Mutually agreed upon. As a rule, the basis of a contract is agreed upon by both parties, the buyer and the seller. Neither party may be forced into signing a contract. Therefore, real estate contracts are voluntary. They must be based on a meeting of the minds. If one party misrepresents information in a contract, the contract is not legally enforceable. Misrepresentation is defined as a statement that is false, and which must have induced one party to enter into the contract. Misrepresentations can be innocent, negligent, or fraudulent, and different remedies are available to the party suffering damages depending on the nature of the misrepresentation. If, for instance, the misrepresentation was unintentional, the adversely affected party may rescind the contract, that is, restore the parties to their original position as if the contract had never existed in the first place. If misrepresentation is found to be negligent or fraudulent, an affected party may also sue for damages. In general, misrepresentation requires a statement by the offending party, admitting to the offense in order to be legally defensible. For instance, lacking disclosure may also result in misrepresentation. Failure to disclose latent defects on the part of the seller will not by itself affect the consent of the parties, but will have similar consequences as misrepresentation. Mutual consent is accomplished through an offer and through acceptance. A fiduciary relationship is one of trust and confidence. It involves one party acting for the benefit of another. For this reason, when entering into a contract, it is important that the offer discloses all facts which could be considered material, even if they were not expressly asked about. Offer. An offer is a promise made by one party, the offerer, to another party, the offeree, expressing interest in contracting under specific terms. Offers must demonstrate a willingness to contract. In most states, they must be written, and they must be unambiguous. having only one possible meaning or interpretation for each identified term. Note: in general, courts will not decipher meaning in the event more than one meaning or interpretation can be derived from the terms provided in an offer. For this reason, offers should include definite terms including subject matter, time for performance, and reasonable price. The overall pretense of contracts is that both offerers and offerees have the same interpretation and inference regarding contract terms. Insufficiently written contracts, such as those which contain superfluous legalese, may invite more than one interpretation. For this reason, it is highly recommended that listing agreements, purchase agreements, and sales agreements be standardized and pre-printed for use. This helps eliminate misunderstanding resulting from ambiguity in the contracting process. Reasons for cancellation of offers. Preceding acceptance. When offers are accepted, they become legally binding. That is, both the offerer and the offeree become legally responsible for fulfilling their respective terms as identified in the offer. However, until an offer is accepted, it can be canceled for several different reasons. Offers are made for limited periods of time. If terms have not been met within the specified time allotted by an offer, the contract is canceled automatically. Offers are canceled when a party does not, or is unable, to meet the contract terms. If an offerer changes his or her interest in selling, he or she has the right to cancel the offer any time preceding notification of acceptance from an offeree. This is called revocation, which is the act of stating officially that an agreement, right, or legal document is no longer effective. If an offerer is declared to be mentally incapable to direct his or her affairs, an offer may be canceled. For example, Irma, an 85-year-old widow, offers to sell her home to her neighbor for the same price she bought it 40 years earlier. After her offer was made, her son Gilbert was able to cancel the sale of the property by showing that his mother was not mentally capable of protecting her own interests. A year later, with the assistance of her son, Irma sold her property through a brokerage at legitimate market value. If an offerer dies before an offer is accepted, the offer is terminated. When a counter-offer is provided by an offeree, the offeree has rejected the original offer, thereby canceling it unless the seller accepts the counteroffer. If a counteroffer is not accepted, the offeree cannot try to accept the first offer unless it is offered again by the offerer. Counteroffers usually result from the existence of terms that an offeree finds unacceptable. By making a counteroffer, the offeree has literally turned the tables to become the offerer. There is a risk taken in this process for the offeree. By countering, the original contract is canceled for the offeree, and the property owners may reject the counteroffer. While waiting to hear back from the offerer, the buyer also loses his or her place in line, thereby allowing the possibility that another buyer will accept the offerer's original contract terms. Real property contracts. Contracts are the basis of buying and selling real estate. A contract is a legal document that affects the buyer, seller, brokers, and every other person involved in a real estate transaction. The contract in a real estate transaction can prevent problems or cause disputes. If the following basic contract law principles are applied, each transaction will proceed more smoothly, with fewer disputes and less liability for the parties and brokers involved. General contract requirements. For a valid contract to exist, there must be an offer, acceptance, consideration, and sufficient specificity so that the obligations involved can be ascertained. K-Line Builders, Inc. v. First Federal Savings and Loan Association, 139 Arizona 209, 677 P2D, 1317, Apicere in 1983. Discussing minimum contract requirements in a case involving a financing contract between a builder and a savings and loan. However, real property contracts must meet certain other requirements and usually contain numerous other important provisions relating to the transaction. Offer. An offer is an expression of a willingness to enter into an agreement, so made as to justify another person to believe that assent to the offer will conclude it. K-Line Builders, Inc., 139 Arizona 209, 677 P2D 1317, App 1983. In other words, an offer creates a power of acceptance, permitting the offeree to transform the offer into a contract. When an offer or counteroffer is not supported by independent consideration, it may be withdrawn at any time prior to its acceptance. Bevins vs. Dixon Electronic Corp., 16 Arizi. App 105 491 P2 494, 1971. Patent v. Paradise Hills Shopping Center, Inc. in 4 Aras App 1118 417 P2D 382 1967. Butler vs. Warely, 5 Aras App 228 425 P2D 130 1967. Any statement clearly implying an unwillingness to enter into a contract according to the terms of the offer, communicated to the offeree prior to unequivocal and unconditional acceptance of the offer, is sufficient to withdraw an offer and prevent contract formation. Although formal notice that the offer is withdrawn is not necessary, written confirmation is advisable. See Butler, 5 Aras. App at 232 425 P2D 130. Further, a written offer can be verbally withdrawn, although again, the verbal withdrawal should be followed by a written confirmation. See Executive Towers vs. Leonard, 7 Aras App 331 439 P2D 303 1968. An offer that has been accepted cannot be withdrawn. Richards v. Simpson, 111 Arizona 415, 531 P2 538 1975. In the Richards case, the court held that the actions of the prospective buyer in subsequently signing the offer after the offer had been withdrawn did not constitute acceptance of the offer while the offer was still open and a contract was not formed. See also Butler v. Warely, 5 Arizona Appiati, 228, 425, P2D, 130, 1967. Acceptance. Acceptance is a manifestation of assent to terms of an offer in the manner invited or required by offer. K-Line Builders Inc. 139 Arizi, 209, 677 P2D, 1317, Aponza 1983. Acceptance of an offer must be conveyed to be effective. Idamois, Empire Machinery vs. Litton Business Telger Systems, 115 Aras, 568, 573, 566, P2D 1044, 1977. Silence does not ordinarily establish acceptance. Farnsworth on Contracts, Par 314P, 231, 1991, citing restatement, second of contracts, Par 56, it is essential to an acceptance by promise either that the offeree exercise reasonable diligence to notify the offerer of acceptance or that the offerer receive the acceptance reasonably. If the offer does not specify the manner for acceptance, any reasonable manner of acceptance will be permitted. If the offer contains no time for acceptance, the seller must accept the offer within a reasonable time. However, if the offer specifies the time and manner for acceptance, that provision will control the outcome of a rejected or accepted agreement. Therefore, when drafting an offer, it should specify the manner and time for acceptance. For example, the AAR resale contract at Section 8P specifies terms of acceptance. This offer will become a binding contract when acceptance is signed by seller and a signed copy delivered in person, by mail, facsimile, or electronically, and received by broker named in Section 8R by at AM, PM, Mountain Standard Time. Buyer may withdraw this offer at any time prior to receipt of seller's signed acceptance. If no signed acceptance is received by this date and time, this offer shall be deemed withdrawn and the buyer's earnest money shall be returned. Acceptance of an offer must be in the exact terms as the offer, and any attempt to accept in terms materially different from the original offer constitutes a counteroffer, which rejects the offer. A counteroffer can become the basis of a contract only if it is accepted by the person who made the original offer. Malkoff v. Coyer, 14 Aries, Appy, 524, 526, 484, P2D, 1053, 1055, 1971. Clark v. Campagna Ganadera de Cananea, S.A., 94 Arizat, 391, 385, P2D, 691, 1963. To create mutual consent and therefore a contract, acceptance of the offer must be unequivocal. Richards v. Simpson, 111 Arizona, 415, 531, P2D, 538, 1975, United Cal Bank v. Prudential Insurance Co. 140 Aris 238, 681 P2 390, 1983. Again, once a counteroffer is made, the original offer has been rejected and cannot be accepted.